Please be seated. Good morning, Your Honor.
Good morning. Welcome to the Massachusetts Appeals Court on this Friday, May 23rd, 2025. I'm Justice Joseph Ditkoff. To my right is Justice Sabita Singh, and to my left is Justice Paul Smyth, and we're the panel for the case today. I know neither of you are strangers to this court, but of course we have our timer. It'll count down 15 minutes, turn yellow when it gets to 90 seconds, and turn red when time's up, and start counting up. There's no rebuttal. We've read the briefs, we've read the record, so you should just get right into your argument. And I'll call our only case today, number 24P1047, JEUNE versus UMASS Memorial Healthcare System. Counselor, whenever you're ready.
Good morning, Your Honors. Attorney Scott Lathrop for the appellant, Rachel JEUNE. And I think I'll be well under 15 minutes. This was obviously an appeal from the Superior Court where summary judgment was entered. This is a COVID-19 religious exemption case. And we're saying, obviously, that summary judgment was incorrectly entered. And there are basically three issues that I see. The first is whether or not UMass Memorial Healthcare System was properly named as a defendant. I think the facts are undisputed that UMass Memorial Healthcare System was the parent company of the entity, if you will, that actually wrote the check to Ms. JEUNE. That's not disputed.
Do we know that? I didn't see any paycheck, any pay stubs in the record.
I don't think there were, but we didn't, shall we say, dispute that you could say on a non-legalistic basis that, yes, this UMass Memorial Health Alliance Clinton Hospital, Inc. was indeed her employer. We're not, from a pragmatic standpoint, we're not disputing that. But we're saying the following, just factually, which is also undisputed, that UMass Memorial Healthcare System was the entity that implemented the COVID-19 policy, that UMass Memorial Healthcare System was the entity that set up the Religious Exemption Committee that reviewed Ms. JEUNE's and everyone else's exemption request, religious and otherwise. It was also that same committee that denied her religious exemption. And finally, on December 2nd, 2021, a person by the name of Justin May, who was the Vice President of Labor Relations of UMass Memorial Healthcare System, notified that Ms. JEUNE was terminated because she purportedly didn't comply with the COVID-19 vaccination policy. Furthermore, as I cite in my brief, under Chapter 151B, Section 4, Subsection 5, a person is liable under that, or entity is liable under that section, if they merely aid and abet alleged discrimination. Minimally, UMass Memorial Healthcare System, as the decision maker here, which is undisputed, minimally they aided and abetted. So there was nothing legally incorrect in naming UMass Memorial Healthcare System as the defendant, as the entity that's practice was being challenged. Second topic I would hit is whether or not indeed Ms. JEUNE submitted a religious exemption. It's uncontested case law, and it's cited in my brief, that first, courts are not to, shall we say, analyze a religious exemption as to whether or not it's logical or whatever. If it's religious in nature, then it's religious. Also, the exemption only needs to be based in part on a religious exemption. And I cited the standard case authority that it only needs to be in part in my brief. Now, counsel wants to argue, well, she said voodooism is the basis for the exemption. Granted, I think in deposition she did testify to that. So, and we can argue this in front of a jury as to whether or not that's also a form of religion. But even if the jury's convinced that voodooism is more socialistic, if you will, socialism theory or whatever. Again, people can have both a scientific point of view and a religious point of view, and the religious has to be honored if it's indeed religious. And as I point out in my brief and in the documents.
Isn't there testimony to the effect?
I'm sorry?
Sorry, isn't there testimony to the effect that, didn't the employee testify specifically that voodooism is, that her beliefs were not a religion?
Well, I don't remember, but even if counsel would convince somebody that voodooism is not religious, it's my analogy, it's scientific in nature, that they believe, oh, it has this effect. Again, she nonetheless, and it's in the documents, in her exemption request for religious, she cites God multiple times. She cites passages from the Bible. How can you say that at least part of her exemption request wasn't based on religion when she cites the Bible? Nobody disputes that. And so that's all that's required. And again,
But at summary judgment, she has to establish a claim. She doesn't have the burden. She didn't move, but she does have to establish there's a claim. And can't she cancel her own claim out by these contradictory statements that my colleague has raised? I mean, if she's saying it's not really a religion.
Again, that means, fine, my brother at trial can cross-examine her about whether or not it's a sincerely held religious belief. But it was inappropriate to grant summary judgment when there's conflicting evidence that clearly is religious of nature. And again, it's in her own documents that she drafted, if you will, on her own. I wasn't involved in it in terms of her application for a religious exemption. And jumping a little bit ahead on the third topic of undue burden, the evidence we cite there is that Ms. JEUNE had worked as a surgical technician for other hospitals during the era when the flu vaccine was mandated by employers. She submitted religious exemptions in those contexts also, which were honored. And so I go back and saying, hey, there's at least evidence that part of her exemption was based upon religion, so therefore it was inappropriate to grant summary judgment. And again, it's the most recent case, and it's a First Circuit case, is Bassinet versus Beth Israel Lahey Clinic, 113 Federal 4th, page 11, issued in August 13, 2024. And I think there's even been a more recent First Circuit case that talks about it only needs to be in part, religious. And again, we've got evidence, even though my brother understandably would want to cross-examine her at trial as to whether or not it was a sincerely held religious belief when there may be contradictory evidence.
So you're saying that the issue of whether it's sincerely held is a fact issue for the jury, and there's disputed issues in this case?
I'm saying, well, actually, yes, because the exemption is always based upon sincerely held, and during the process that we had, I don't believe that anyone questioned whether it was sincere or not. And I always tell my clients when they talk to me about it that, if you said something totally inconsistent, or
they didn't agree it was sincere, did they? I didn't see that. Obviously, that's a jury issue, but I didn't see any concession that it was sincere.
Your Honor, you're correct. They did not explicitly come out and say it, but they didn't challenge it on that basis, if you will. It got challenged, and the issue currently is in front of you.
Let's go back to then. Are you also saying that the issue of whether it's religious in nature is a question of fact on this record?
Yes, minimally a question of fact. And obviously they're disputing that. They're saying, oh, her exemption wasn't religious in nature, so that's disputed, which means we still should have a trial. In terms of the third topic, the undue burden, yes, legally if an employer, which has the burden of proof, can prove that grant an exemption would create an undue burden, that can override the, shall we say, request for a religious or disability exemption. We understand that, but the burden of proof is on the employer, and there was no evidence that I recall at all in the record in terms of them advancing factual evidence in support of an undue burden. But even if it had, that's also disputed, because Ms. JEUNE presented evidence, which I've already talked about, that her evidence, which she would present at trial, is that, hey, I asked for a religious exemption for all the flu vaccine mandates, and with prior employers, the very same position, very same duties, and they granted it as long as I wore a mask, and everything was fine. So that would be the evidence that she would use to contradict any evidence, assuming there is some, that granting an exemption from the COVID-19 vaccine would have created an undue burden. So that's also a topic that I believe is disputed and can be decided by a jury, not by summary judgment. And that's my summary of our position. Any questions?
Just one more follow-up on the first issue. In the party's undisputed statement of facts, you agreed essentially that the named defendant, UMass Memorial Healthcare System, was not the employer of the plaintiff, the complainant. So why wasn't Judge Wren correct in stating you didn't correctly plead this case?
Because under 151B, Section 5, subsection 5, to be named under that statute as a defendant, if you will, first at the MCAD, then in court, you don't have to be the employer. That's why individuals who are managers, supervisors, get named as parties all the time and in court. So again, I'm saying yes, in this, as I've already said, in the pragmatic sense, this subsidiary, wholly owned subsidiary, was the one that day to day said, do this, we'll pay you $10 an hour, or whatever her salary or wages were. We don't dispute that, but I'm saying, hey, 151B is much broader than limiting it only to that kind of employer. You don't have to be the employer. You just need to be aiding and abetting. And again, since pragmatically, UMass Memorial Healthcare System was the entity that did everything, which Ms. JEUNE is contesting, that's the party that we wanted to hold accountable. Okay?
All right, thank you.
Thank you very much.
If you want your assistant to sit up there, that's fine.
Oh, thank you, Your Honor.
Whenever you're ready, Counselor.
May it please the Court. Good morning, Your Honors. Bob Kilroy on behalf of UMass Memorial Healthcare Corporation. Healthcare Corporation is the actual parent. There's no such entity as a UMass Memorial Healthcare System, as Judge Wren found. Appellees argue for affirmance of Judge Wren's order on summary judgment on each of three independently sufficient reasons to affirm his decision. The first is the one that my brother counsel started with, which is the issue of whether or not the correct employer was named. There's no dispute here. The actual employer was not named in this case. There's also no dispute. There's no aiding and abetting account in this case. There was no complaint filed listing an aiding and abetting count, which is what you would typically see if there was a claim for aiding and abetting, and there was no argument presented. Certainly there was no discovery taken on aiding and abetting. No argument presented other than one line in the oral argument at summary judgment, and as I recall, one line in the appellant's brief.
But you agree that there is liability for aiding and abetting, however, it might not have been perfectly set forth in this complaint.
Yes, Your Honor, we agree that there can be liability for aiding and abetting if the correct entity is named, certainly.
So the termination letter says This letter concerns your separation from employment with UMass Memorial Health. You will be separated from employment with UMass Memorial Health effective today. Why doesn't that by itself create a jury issue as to whether she was employed by UMass Memorial Health?
Because the evidence is overwhelming as to who the actual employer is, Your Honor. UMass Memorial Health is the equivalent of a trade name. So there is a healthcare system as a whole with multiple entities, multiple subsidiary hospitals. She belonged and was employed by one of those hospitals. There's an offer letter in the record that makes clear she's employed by UMass Memorial Healthcare Alliance. And then beyond that, you would look to whether or not there can be parental liability. The actual parent of Health Alliance was the corporation, UMass Memorial Healthcare Corporation.
Well, she could work for both, couldn't she?
Well, she could be joint employed by both if, in fact, the joint employment test was met. And there's a four-factor test that is cited by my brother counsel. It's cited in our papers as well. And the evidence is undisputed in this case. She does not meet a single one of those.
Really? I mean, they had the power to fire her. They did fire her. They set some of the conditions of employment. They just set whether she had to have the vaccine. The only employment records in this summary judgment record are UMass Memorial records. There's not a single one from the hospital. And I didn't see any evidence about who determined the rate and method of payment in this record. What am I missing? It seemed like every single factor supports joint employment.
The termination letter, Your Honor, is on UMass Memorial Medical Center letterhead. It's not on a healthcare system corporation letterhead. The individual who executed the termination decision was the vice president of UMass Memorial Medical Center. That was his employer. He was essentially leased out to all entities where he provided oversight across all entities for labor relations matters, but he was not acting on behalf of the corporation. And in terms of the
Also, the first sentence of the letter states this letter concerns your separation from employment with UMass Memorial Health.
Correct. And as I mentioned, Your Honor, that's essentially referencing the trade name of the system-wide. But if we look at who actually has the power to hire and fire, Justin May was acting on behalf of the separate entities when fired.
How do we know that?
There's not record evidence of that, Your Honor, I would agree, in terms of being able to state that specifically.
So a jury could find in favor of the other party on that issue.
On that specific count, I would agree that we would need more evidence in the record, Your Honor, to address that. There's certainly no evidence to suggest that the parent supervised or controlled the work conditions or performance.
They set her vaccination requirements, right?
The
only condition of employment I know of in this record is the vaccination requirement, which was set by UMass Memorial, not by the particular hospital, right?
It was set at a system-wide level. That's correct, Your Honor. And there's no evidence as to determining rate of pay. With that, Your Honor, I would move on to the other two arguments. The first being the question of her religious exemption request. And appellee would argue that it fails because her request is not based on religious beliefs that have been recognized by courts as warranting accommodation. First and foremost, her request is based on false information that the COVID vaccines alter her DNA. One, there's no evidence that's been presented that supports that assertion that's found in her religious exemption request, and it's because it's truly false. And more importantly, it's a medical belief, not a religious belief. Secondly, she cites that the vaccine contains genetic coding proteins, again citing no evidence to support that statement. The reason being is because there's no evidence to support that statement, and again, that would be a medical statement as opposed to a statement of religious belief.
But isn't there case law that says that religious beliefs don't have to be logical?
Yes, absolutely. They do not have to be.
You're giving us an argument that her religious belief should be discredited because it doesn't make sense. It's not logical.
Actually, the more salient point I'm offering, Your Honor, is that she is citing to medical statements as opposed to religious statements. So whether they're logical or not, she's citing to something that courts have recognized. If you're making your religious exemption request based on medical statements or safety, efficacy of the vaccines, that does not rise to the level of a religious exemption request.
Isn't her objection putting this foreign material into her body against what she feels God would approve of or disapprove of?
There's certainly a statement to the effect her body is a temple, and courts throughout the nation have addressed that and found that that's an isolated moral teaching as opposed to something that warrants religious exemption. She relies on two specific biblical verses. The first is Genesis 1:27, mankind being made in God's image. The second, 1 Corinthians 6:19-20, which references the body as the temple of God or the temple of the Holy Spirit. Neither of those say anything about vaccines in general, about the COVID vaccine more specifically, and most notably, in Record Appendix Volume 2, page 104, Ms. JEUNE is specifically asked, and I'll quote, "Do you claim any scripture in the Bible is the reason you refuse the COVID vaccine?" Answer, no. That's the end of the inquiry with respect to her Bible verses and in terms of what she's putting in her body.
Are you familiar with you cite Thornton, and I think you did it before the First Circuit opinion. Are you familiar with the First Circuit opinion there?
In Thornton, Your Honor?
You cited Thornton, I think, before the First Circuit decided it. Are you familiar with the First Circuit opinion?
I don't recall it off the top of my head, Your Honor, no.
Right. I assume you're not familiar with the Fourth Circuit case in Barnett or the Sixth Circuit case in Sturgill?
No, Your Honor.
All right, that's fine.
She also references following her conscience or praying to God for guidance with respect to referencing her body as a temple of the Holy Spirit. And the courts, including the District Court of Mass, Judge Saylor in particular, have noted that this would create a blanket privilege, allowing employees to opt out of any and all employer requirements simply by stating they prayed and received guidance or their conscience dictated that they refuse a vaccine. And specifically, I would cite Griffin v. Mass Department of Revenue, Judge Saylor's decision where he states, "Claiming I prayed to God and was shown I should not get the vaccine without more is insufficient to support a claim of religious discrimination." I'd also point to the Hand v. Bay Path Medical Center case, District of Delaware, 2024 Westlaw 359245, which states, "Forcing defendant to unfailingly respect any decisions plaintiff makes by praying and asking God for wisdom and guidance would grant her the type of blanket privilege that does not qualify as religious belief." And then the last case I would cite on this particular argument, Your Honor, is the Prida v. Option Care Enterprises case out of the Northern District of Ohio, 2023 Westlaw 700-3402 at pin site star 5. There the court states, "Prida's alleged religious belief that her body is God's temple would, if allowed, grant the plaintiff carte blanche to accept or reject nearly any condition of her employment. Accordingly, courts have routinely rejected failure to accommodate claims based on such blanket assertions, finding that they present isolated moral teaching rather than sincerely held religious beliefs." And on that basis, we do not believe that her religious belief is a question of fact, but rather it's been decided throughout the country in multiple cases, and we cite many more in our papers.
Pretty much all by district courts.
That's
right?
correct.
Individual judges.
That's correct, Your Honor. And that's just where they have ended up at this point from Appellee's research. The last argument I would make, Your Honor, is that the exemption request was properly denied as recognized by Judge Wren because it would have resulted in an undue hardship as a matter of law.
So your hospital has a religious exemption, right?
They
to
do,
this.
Your Honor.
So how could it be an undue hardship if you actually allow or you accept the religious beliefs people to be exempt?
Because the undue hardship analysis, Your Honor, would be done on an individualized case-by-case basis, depending on position. In her case, she was a surge tech who worked in the operating room with a vulnerable patient population. She certainly could not maintain social distancing of 6 feet. She was in close daily contact with vulnerable patients, with surgeons, with fellow coworkers, and all of that has been recognized by multiple courts as something that creates...
Well, in Together Employees, there was an affidavit by Dr. Klompas explaining the problems, and I didn't see anything like that in this record. I didn't see any affidavit from a doctor explaining why a mask wouldn't be enough. Did I miss it?
Explained by...
Why masks wouldn't be enough, and because there is it does say if you get an exemption, you have to wear an N95 mask, and you have to be frequently tested, and you have to eat alone. And I didn't see anything saying that wouldn't work for a surgical tech. Was there something I missed in the record?
You did not, Your Honor. There have been cases, however, that have fully recognized that masking alone is not as effective as is vaccination. And in particular, there's a case that came out within the last month, Your Honor. McCarthy v. Mass Department of Children and Family Services. It's an April 23rd, 2025 decision by Judge Stearns. And he states here at the time of...
Could you give me the site for that?
Yes, Your Honor. It is Audrey McCarthy v. Mass Department of Children and Families, civil action number 23-11258-RGS, April 23, 2025, Judge Stearns. And it was a decision on summary judgment. And the judge notes, at the time of her
do you have a Westlaw or a Lexis site for that?
I do not, Your Honor.
All right, I could probably find. Let me make sure I got it. It's 23. Actually, why don't you just submit it, the opinion, the decision you're looking at in a letter afterwards?
I will, Your Honor.
That'd be real helpful.
The relevant language is on page 6. It says here at the time her exemption request was denied, the general medical consensus based on objective data provided by public health authorities was that vaccination was more effective in preventing transmission of the virus than masking and testing alone. And he cites to the Rodriguez v. Hearst Communications Incorporated decision, 126 F4th 85, pin site 92, First Circuit decision in 2025. And then the most salient case, Your Honor, and I...
Before you move on, so what, are you saying that there couldn't be some accommodation where her duties could be changed? She didn't have to work in that particular atmosphere?
Correct, Your Honor. She admits at deposition that in order to do her job, she cannot do it remotely. She has to be present. And even prior to the vaccination requirements, she was masked anyways. They're masked in an operating room. But in order to avoid the risk to the harm to patients, if she happened to be infected and not yet showing it in testing yet, risks the harm to the surgeons, and then risks the harm to the reputation of the hospital, because if it gets out in the public that we've become a super spreader, essentially, based on the fact that we're not requiring people in the OR to be vaccinated.
Could she be reassigned to another duty besides being in the OR?
That was never requested, and so for instance, could she have been assigned to patient registration that was done solely by phone remotely? It's an open question. I believe that from a strictly logical perspective, that would be permissible. I'm not aware that they have any, that they had any positions like that.
Are you saying that no nurse in the system got a vaccine exemption?
That I'm not positive as to the specifics of who may have had a exemption. I'm not aware of anyone who was in an operating room receiving an exemption, Your Honor.
What about in a non-operating nurse context?
I believe that it's likely that there was.
And why couldn't she have been put there as an accommodation?
It would be a function of, was there any openings to place her at something like that? But there certainly was never a request to be put there, nor am I aware that there were any
Well,
openings.
sure, because you didn't do the accommodation process because they rejected the religiosity of the belief altogether. So we never got to the accommodation stage, right?
Well, they certainly got to the accommodation stage of the accommodation she requested, which was to be accommodated to work just masked in the OR. They didn't go beyond that in terms of any discussion as to other positions that might have been available. And you're correct that they made the decision based on the fact that she was relying on false information. If I might, I recognize I'm over my time. If I might just conclude with what I believe is the most pertinent decision that came out within the last 11 days from the U.S. District Court for Massachusetts, a decision by Judge Murphy. And if I may hand the decision up to the clerk.
Well, why don't you give us that decision and the McCarthy decision? Just, submit it electronically.
I will, Your Honor.
Attached to a letter so that we all get it and your brother and your friend gets it, and that'll be but we will definitely take a look at that.
Great, thank you, Your Honor. And the decision is Levine v. Mass General Brigham Incorporated, 23-10987-BEM. And the key here was it was almost on all fours with what we're seeing here, with the exception that the nurse at Mass General was not in an OR. Nurse Levine worked in the hospital, inpatient with patients, had to deal with family members of the public and coworkers, took vitals, administered medications, drew blood. Couldn't remain 6 feet away. And Judge Murphy's decision on undue hardship, he states, the undue hardship defense is built into the statutory definition of religion such that an employment action cannot constitute discrimination and an employer cannot be liable under Title VII for religious discrimination if the undue hardship defense applies, and he references the Bazinet decision out of the First Circuit. He then goes on to identify relevant factors for addressing undue hardship as a matter of law, and those included non-economic costs.
We'll read this and the other decision as soon as you get them to us.
Thank you, Your Honor. He concludes with finding that undue hardship was compelled as a matter of law in that case. And I thank the court for its attention.
All right, thank you both. I'd like to also thank our timekeeper, our court officer, and our clerk's office. I wish you both a meaningful Memorial Day. I hope you'll spend some time not just having a cookout, but also thinking about the soldiers who died defending this country. You look like you want to say something.
Your Honor, I'm just wondering, to the extent my brother wants to submit more recent cases, there's a more recent
Great.
circuit case that I'd like to submit.
Yes, please do. Yeah, both of you. Submit whatever cases you'd like. Say by the end of next week, submit any new cases that you'd like. Those two cases you talked about, any case you'd like, yeah, please do. Both of you. Please give us whatever cases you'd like. If they're unpublished, please give us the actual case. I mean, if it's published, you can just give us the site, but if it's unpublished, please give us the opinion. That'd be great.
My research, this is a First Circuit January case that deals exactly with this religious exemption of COVID-19.
Great.
And I just saw that there is a citation of federal or fourth volume, or whatever they call it. Should I just submit that name to you, or do you want to-
If it's published, all we'll need is for you to just tell us the case name and the citation.
I will do that.
And I've done some research myself, as you probably deduced from some of the cases I mentioned. But yes, please, by the end of next week, give us any citations, or if unpublished opinions, give us the unpublished opinion, and we'll like to look at whatever cases you guys can give us. All right, so all that having been said and done, court will stand adjourned until Monday, June 2nd at 9:30 a.m.
Good seeing you, Scott.